Okay. Good evening and good morning, based on where in the world you are, and welcome to the Global Environmental Law Center's webinar. I am Dr. Melandri Steenkamp, and I'm a researcher at the center. And today we have the pleasure of hosting Jorge Alejandro Carrillo Banuelos on the webinar on climate litigation and nationally determined contributions above and beyond accountability. Jorge serves as a climate change and human rights advisor at the Supreme Court of Mexico, and in his role, he has coordinated several national training programs that are focused on climate change and environmental law. You can see a little bit more on his experience on the slide in front of you. Jorge will have approximately 30 minutes to present on this topic, and thereafter we will facilitate a question and answer session. You are welcome to also pop any questions or comments that you have during the course of the presentation into the chat box, and also to raise your hand after the presentation. I will hand over to Jorge, and again, welcome everyone.
Thank you so much, and thank you for this invitation. I'm very excited to be here today. Good morning or good afternoon. I'm very excited to talk about climate litigation and nationally determined contributions. Actually, I will try to summarize some of the conclusions of my article, which is basically called Climate Litigation and Nationally Determined Contributions Above and Beyond Accountability. I would like to speak for about 30 minutes and so that we can have a space for your questions or comments. I will be thrilled to hear any particular questions that you find interesting about the presentation. And yeah, I will now try to share my screen. Yeah, so I think it's working now, right? Perfect. So I would like to start by highlighting that the importance of nationally determined contributions. As you may know, the obligation to prepare, communicate, and maintain NDCs or successive NDCs is one of the key obligations under the Paris Agreement. And an NDC basically is a document that includes or describes the efforts of each country that has signed and ratified the Paris Agreement. This document includes the efforts to adapt to the impacts of climate change and to reduce greenhouse gas emissions. In Paris Agreement, we can also see that parties shall pursue domestic measures with the aim of achieving the objectives of the NDCs. And of course, some of these objectives, we can find the objectives in Article 2 of the Paris Agreement. One of the most important ones is holding the increase in the global average temperature to well below 2 degrees Celsius and even pursue efforts to limit the temperature increase to 1.5. And according to the Paris Agreement, NDCs are submitted at least every 5 years. This is not a very restrictive rule because states can submit NDCs every 2 years, every 3 years. We will discuss some cases today, and actually, for instance, the Mexican government has submitted NDCs every 2 years. But of course, according to the Paris Agreement, in any case, they have to submit an updated NDC at least every 5 years to the Secretariat of the United Nations Framework Convention on Climate Change. And also very, very important for the purpose of this presentation, under the Paris Agreement, and to enhance ambition over time, successive NDCs need to represent a progression compared to the previous NDC and also reflect the highest possible ambition. And just to mention or discuss a bit more the importance of NDCs, here on the screen you can see some of the conclusions of a report called Emissions Gap Report 2024 from the United Nations Environment Programme. And this emissions gap report has a special focus on what is required from NDCs to maintain the possibility of achieving the long-term temperature goals of the Paris Agreement, as I mentioned, basically keeping the temperature well below 2 degrees Celsius and 1.5. And in its core, the message in this report is that ambition means nothing without action. And actually, one of the conclusions of the report is that collectively, the countries that are members of the Y20 are still assessed to miss their NDC targets for 2030. And furthermore, the NDC targets, the current NDC targets of the G20 are far from the average percentage reductions that are required to align with the objectives of the Paris Agreement. So we have several NDCs from countries of the G20 that are not sufficiently ambitious, according to this report, to fulfill the objectives of the Paris Agreement. And the report also mentions that countries should consider the following suggestions as they prepare their next NDCs, including meeting the highest standards. And this basically means that the NDCs need to cover all sectors, specify specific targets, and be explicit about the conditional and unconditional commitments, because in most of these NDCs, we can see that countries commit to certain objectives in a conditional manner or unconditional manner, depending on resources and support or international cooperation. And according to this report, states need to be clear about this kind of conditional and unconditional commitments. And also, NDCs must be transparent and clear, and countries must be transparent and clear about how the NDC that they submit reflect the highest possible ambition. And remember, this is a wording that we can find in the Paris Agreement expressly, that the NDCs must represent a progression and reflect the highest possible ambition. And now I would like to talk a bit about climate litigation. And here on the screen, you can see the cover of the Global Climate Litigation Report 2023 Status Review. This is published by the United Nations Environment Programme in collaboration with the Seventh Center for Climate Change Law at Columbia University. And we can see in this report that as of December 2022, there have been 2,180 climate-related cases filed in 65 jurisdictions. And actually, I believe the UNEP and the Seventh Center are working on the next edition or the next Global Climate Litigation Report. But recently, the Grantham Research Institute for Climate Change and the Environment from London School of Economics and Political Science published another climate litigation report, which is called Global Trends in Climate Litigation 2025. And we can see that this report already considers the cases that were filed in 2024, and that the number, and one of the conclusions of the report is that the total number of cases filed to date, it's nearly, we have nearly 3,000 cases globally. And of course, we see new cases every day, at least in Mexico. I can see that we have more and more cases. Even this month, I realize that some courts are reviewing more climate litigation cases. So of course, this number is increasing very rapid. It's very rapidly over time. And according to this report that I have on screen, several domestic cases relate to international obligations under the Paris Agreement. So basically, we have several cases that have been brought to determine whether specific mitigation and adaptation efforts are adequate to meet the objectives of the Paris Agreement. And we can see a lot of cases where plaintiffs are challenging legislation, policies, projects that are considered not to be compatible with the objectives of the Paris Agreement. And more interesting, at least for the purposes of this presentation, is that the Paris Agreement has been invoked in cases against projects or policies that may be inconsistent with the NDCs. So now we have courts that are analyzing policies, legislation, projects, and other actions in light of the commitments under the NDCs. And this is not surprising if we consider that in several countries, the governments or the Congress or other authorities are integrating the NDCs into domestic legislation. Um, and actually, in the NDC synthesis report from 2023, we can see that 48% of the parties to the Paris Agreement have integrated their NDCs, targets, goals, and policies into legislative, regulatory, and planning processes. And basically, the report also mentions that NDCs hold greater promise of being achieved if they are integrated into each nation's domestic laws. And this is the case of Mexico, to provide an example. Here in Mexico, we have a general law on climate change, and this statute basically incorporates the objectives from the Paris Agreement, the objectives from the United Nations Framework Convention on Climate Change, and the emission reduction targets of the Mexican NDC. Just to provide an example, but according to this report, almost 50% of the parties to the Paris Agreement have already integrated these commitments into their domestic law. So now, trying to focus on their relationship between climate litigation and NDCs, one of the first conclusions of the article that I'm discussing today is that the domestic enforcement of the NDCs is a relevant strategy to advance the goals of the Paris Agreement and ensure its implementation. And this is particularly important if we consider that countries are off track to achieve their NDCs. And actually, in one of the emissions gap report, the emissions gap report from 2022, um, the report mentions that countries, and here I quote, are off track to achieve even the globally highly insufficient NDCs. So basically, we have NDCs that are not sufficiently ambitious to meet the goals of the Paris Agreement, but also states are not implementing them. So basically the government submitted the NDC with certain goals, certain commitments, specific mitigation and adaptation actions or efforts, but countries are not implementing those efforts at the national or domestic level, even if these commitments are considered not to be sufficiently ambitious. So courts can also play a role in enforcing new and updated NDCs. Basically, if a state is not implementing its NDC, if it's not pursuing domestic measures to achieve the objectives of the NDCs, if the government is not pursuing measures to fulfill those commitments in the NDCs, including mitigation and adaptation commitments, plaintiffs go to courts basically to require the government to enforce and implement the existing NDC. But something that is also interesting, if we see some of the climate litigation cases on the global databases, is that courts can also review the content, goals, and level of ambition of the NDCs. And this is especially important if we consider, again, that according to the emissions gap report and the NDC synthesis report, most of the NDCs are not sufficiently ambitious and are not in line with the objectives of the Paris Agreement. We need to do more. We need to be more ambitious. These commitments need to be reflect a progression in order to achieve the objectives of the Paris Agreement, including the goal to the temperature goals regarding 2 degrees and 1.5 degrees Celsius. And this climate litigation can help ensure that NDCs are progressive and sufficiently ambitious. And here on the screen, you can see the names of 4 cases that I think are especially interesting to discuss this relation between climate litigation and NDCs. We have a limited time today, so I basically will cover just the first 2 cases, but here you can see the complete name of the case, and you can see more information if you check the Global Climate Litigation databases of the 7th Center. You will find more information about these 4 cases. And the first case that I want to discuss is actually a Mexican case, so I feel more comfortable or I have more personal knowledge about this case. This is Greenpeace versus ENIC and others. You can find the case in the databases with this name. And basically, in 2021, the organization Greenpeace Mexico filed a lawsuit against several government agencies here in Mexico, arguing that the country's updated NDC violated the right to a healthy environment and the international commitments under the Paris Agreement. To provide some context, here in Mexico, we have the right to a healthy environment in Article 4 of the Constitution. And to provide some context on the NDCs, Mexico submitted its first NDC in 2015. Then it submitted an updated version of the NDC in 2020. And basically, the NDC maintain the same level or the same percentage of emissions reduction as in the NDC from 2015. Basically, in 2015, the government included the commitment to reduce greenhouse gas emissions by 22%. And in the updated NDC from 2020, the government basically included the same percentage, reduce greenhouse gas emissions by 22%. And Greenpeace Mexico filed this claim and actually mentioned that the NDC relaxed the goal of reducing greenhouse gas emissions by 22%, basically because it changed the business as usual baseline in 1.8% and allowed the emission of an additional 14 million tons of carbon dioxide equivalent. And on September in the same year, in 2021, a district court granted an injunction. Basically, this was a preliminary decision or a preliminary process, and the court decided to suspend the country's NDC until the court decided on the merits. And basically, the court mentioned that the NDC allegedly modified in a regressive manner the commitments of the Mexican government under the Paris Agreement. And let me emphasize that the court used the words allegedly modified because this was a preliminary analysis. This was not the merits analysis. So basically, the court decided at a first glance if we can see that that way. And basically, the court argued that NDCs must represent a progression and reflect the highest possible ambition using the language of the Paris Agreement and Article 4 of the Paris Agreement. And interestingly, the court also linked the right to a healthy environment with Article 4 of the Paris Agreement and the principle of progressive realization or progressivity of human rights under the human rights law, which has also been interpreted in Mexico and several other countries and other courts in the world, has been interpreted also as a non-regression principle. This basically means that once a certain level of environmental protection has been reached, once a certain level of human rights protection has been reached, our government agencies or government authorities are prohibited from reducing that level of protection without a solid justification. And under the jurisprudence of the Mexican Supreme Court, for example, this means that the government needs to argue that this decision in particular that can be considered regressive pursues a constitutional objective, it's necessary, it's adequate, and it's proportional. So it's basically a very strict analysis, and the government needs to argue that the decision to reduce that level of environmental protection actually pursues this constitutional objective, it's adequate, it's necessary, and it's proportional. And it's in most cases, it's very difficult to argue that a decision from the government actually fulfills those requirements. So basically, the district court mentioned that NDCs also need to be analyzed or reviewed under the principle of progressive realization of human rights and the non-regression principle. And then a few months later, the court decided on the merits, and basically the court considered that the plaintiffs did not provide enough evidence to prove that the NDC allowed the emission of an additional 14 million tons of carbon dioxide equivalent But something interesting that happened is that when the court issued the preliminary decision, a lot of organizations and a lot of groups and a lot of activists mention or tried to communicate that the government needed to increase the level of ambition. So basically, they put a lot of pressure on the Mexican government. And even without a court decision ordering the government to present a new NDC, the Mexican government decided to update the NDC again, and they submitted a new NDC with a new commitment of emissions reduction in 2022. So basically, even though the court on the merits did not find any violation to the right to a healthy environment, several organizations and several groups put a lot of pressure on the government, and the government decided to submit a new NDC. Another one of the cases that I want to discuss today is Six Youths versus Minister of Environment and others. This is a Brazilian case. And here, basically, and this is also 2021, several young activists filed a popular action. It's called popular action in Brazil, which is basically a procedure for the protection of human rights and constitutional rights. And they filed this action against the Minister of Environment and another authorities, uh, claiming that the NDC that was submitted by Brazil in 2020 was less ambitious than the previous one that was presented in 2015. And they also argued, very similar to the Mexican case, that the NDC allowed the country to reach the year 2030 with additional emissions. This was a bit more, 200 to 400 million tons of carbon dioxide equivalent. And the court and the activists asked the court to declare the nullity or strike down the NDC, require the government to present a new NDC more progressive and more ambition that actually fulfills the requirements of the Paris Agreement, and to condemn the defendants or the government to pay damages. And when the court received the case in 2021, a federal court recognized its authority to review the case, basically because Brazil signed and ratified the Paris Agreement. So this is a discussion the courts can have in Brazil. That is the conclusion of the federal court. But the court did not decide on the merits, basically because the government in 2023 signed an agreement with the plaintiffs to settle the case. And basically the government committed to provide a more progressive um, emissions reduction target in a new NDC, and also to set a very transparent and very very participatory process in the creation of the new NDC. And actually, Brazil submitted a new NDC this year, actually following this process, which has had more access to information, more public participation, which was one of the commitments in this agreement that the government signed with the plaintiffs in this case. So we can see that from at least from these two cases and several more cases that we can find in the global climate litigation databases, that plaintiffs and several jurisdictions are already challenging the content, goals, and level of ambition of the NDCs, and that the arguments in most of these cases have been or intend to illustrate the incompatibility between the NDC and the Paris Agreement and human rights obligations, and in particular the human right to a healthy environment. And so far, at least two of these cases, the cases that I discussed today, have been an effective mechanism to promote the adoption of more progressive and more ambitious commitments. Remember that in the case of Mexico, even though the court did not rule in favor of the plaintiffs, the Mexican government decided to present a new NDC. And in the case of Brazil, even though the government reached or signed an agreement with the plaintiffs, the government decided to present the new NDC with a more public process and granting public participation. So at least two of these cases have been an effective mechanism to promote more progressive and more ambitious climate action. And I now want to turn to the question, what remedies can a court order in these cases, or what effects should the judgment have Of course, the nature and the scope of these remedies that courts may provide in climate litigation cases depend on the cause of action, the available legal action or procedure, and of course, more broadly, the legal system in which the action has been brought. Today, we discuss some of the remedies that courts can order in Mexico and Brazil, but we can see that in most cases, courts can issue prohibitory injunctions, which basically means ordering the government to refrain from implementing an NDC. This is the case of Mexico, for instance. Remember that the Mexican court suspended the NDC and ordered the government to refrain from implementing the NDC because it was considered less ambitious than the previous one. And also the court ordered the government, I think I forgot to mention this, they ordered the government to apply the previous NDC, the NDC from 2015. And in some of these cases, we also see that courts can issue mandatory injunctions. This basically means that the court can order the government to submit and implement a more ambitious and more progressive NDC. This is exactly or precisely what the plaintiffs requested in the Brazilian case. And this was also what the plaintiffs required in the Mexican case. And I want to emphasize that both prohibitory and mandatory injunctions will be necessary in most cases because the remedy could entail striking down the NDC, but at the same time ordering the government to present a new one. And we have to be very careful here because I think we need to think that the process of creating and submitting an NDC takes time. It can take weeks, it can take months, it can take more than a year. And I think the worst case scenario is when we don't have an NDC to implement. So a complete lack of implementation of the current NDC or the previous NDC may further impact the rights of the parties or the plaintiffs, but more broadly, the international commitments under the Paris Agreement. So that's why the Mexican court in the Mexican case, ordered the government to implement the previous NDC because, again, the worst case scenario is when where we don't have an NDC to implement. So, in most of these cases, the courts can order interim measures or a transitional regime, at least during the time that the government is preparing and submitting a new NDC. And now I think I have a couple of minutes just to address these final questions. Do these decisions, these climate litigation decisions on NDCs, uh, must be reported to the UNFCCC Secretariat? Should it be part of the transparency framework of the treaty? Of course, if a court orders the government to present a new NDC, this NDC will be reported to the UNFCCC Secretariat. What is less clear is whether government authorities or agencies must report to the Secretariat that a domestic court has ordered the submission of the NDC. And it's also it is unclear whether these government authorities must specify the reasons or even provide access to the ruling that where the court actually strike down the NDC and order the government to present a new one. And of course, these questions don't have a definitive answer. We can talk about examples from Mexico and Brazil, but of course, there's nothing about climate litigation on the Paris Agreement. We don't see anything that actually gives us a clue if we should report the activities of the courts to the UNFCCC Secretariat. But we have some articles or several articles in the Paris Agreement that might give us some light on how to proceed with this increasing number of climate litigation cases. For instance, Article 4.8 mentions or emphasizes that the information that in communicating their NDCs, all the parties shall provide the information necessary for clarity, transparency, and understanding. And the Paris Agreement emphasizes that this information is especially important to inform the global stocktake under Article 14 of the Paris Agreement, We also have Article 13 mentioning that the purpose of the framework of transparency is to provide a clear understanding of climate action in light of the objective of the convention, including clarity and tracking of progress towards achieving parties' individual NDCs, and that each party shall regularly provide the following information, including information necessary to track progress made in implementing and achieving the nationally determined contributions. And I arguably information on climate litigation and NDCs would contribute to transparency, enhance progress tracking, and even using the words of the Paris Agreement, build mutual trust and confidence between the parties to the Paris Agreement. So under this argument, the decisions in climate litigation cases regarding NDCs must be reported to the UNFCCC Secretariat. But again, this is not a definitive answer. This is the argument that I present in the article that I'm talking about today. But of course, perhaps we will see more information and we will have a clear answer to these questions, considering the increasing number of climate litigation cases where plaintiffs are basically challenging the content and goals and level of ambitions of the NDCs. So basically, this covered the topics of the presentation that I had planned for today. Now I would be happy to answer some of your questions, or if you have any comments, of course, they are very welcome. Thank you so much for your attention.
Thank you for that incredibly informative presentation, Jorge. We are now open for questions from the audience. I see we do already have one question. If anyone wants to raise their hand and ask the question directly, you are also free to do so. I will keep my eye out for that. I'm going to read out one of the questions in the comments from Natalia Mendoza, who asks, who are in charge for the update of the NDCs? Is this a job that is only assigned for public institutions, or can citizens also be a part of them? And while we also wait for further questions, I would like to ask, only because I've recently thought about this a little bit, when it comes to the courts increasingly being seen as almost activists in the climate space. What are the democratic or legitimacy concerns when it comes, especially to the doctrine of separation of powers, when it comes to courts also changing or ordering changes to national policy? And have the courts been faced with similar arguments from opposing parties? If you can maybe reflect on that. Okay.
Sure, definitely. And thank you so much for the questions. They're very good questions. Starting but with the question of who is in charge of the update of the NDCs, under the Paris Agreement, countries and government authorities are in charge of updating the NDCs. This is very different, of course, depending on the country. For instance, in Mexico, we have a Ministry of Environment, and most countries have ministries of environment. So basically, this ministry will basically guide the process of creating the new NDC and submit the new NDC. But of course, other authorities can participate in the process. And something that we are seeing in some, at least in some countries in Latin America, is that the government is creating more public processes than trying to guarantee access to information and public participation. I think in the case of Mexico and Latin America and the Caribbean, one of the main reasons from this change in the process is basically that we have a regional treaty called the Escazú Agreement, which basically recognizes the rights of access to information, public participation, and access to justice in environmental matters. So basically now all countries or most countries that have ratified and the Escazú Agreement are obliged to guarantee these rights in all the environmental decision-making processes. And NDCs are one of these environmental decision-making processes. So now we have governments such as the Mexican government and other countries in Latin America basically allowing citizens to inform the process of the NDC, present opinions, participate, have hearings, among other forms of participation. So I think And I believe this is the ideal scenario, where you have participation from different actors, because again, what we can see from most of these cases is that even though the government can have a specialized teams and specialized people that are actually working on the NDC, sometimes they don't have all the picture. They don't know, for instance, if some local knowledge, traditional knowledge, indigenous knowledge that needs to be considered in the process. And under the Paris Agreement, that is also mandatory. So basically, countries needs to consider the best available science, but also the local and indigenous and traditional knowledge. So I think that's why NDC must be a participatory process. And the second question, I think this is one of the most important questions right now in several countries, including Mexico, because basically in the cases that we discussed today, the courts are concluding that the government is not being sufficiently ambitious, that it's not doing enough, that it's not fulfilling its objectives under the Paris Agreement. And this is difficult because under the Paris Agreement, each government decides how to comply with the Paris Agreement. They have the liberty or the discretion to decide the specific commitments and how they will fulfill those commitments. But something that we are seeing in these courts is that basically they're saying uh, you have international commitments under the Paris Agreement. You have to, one of those commitments is to, regards to the long-term temperature goal, basically to maintain the increasing global average temperature to 2 degrees and even 1.5 degrees. And this is a scientific discussion. This basically means that we need to take all the action according to the best available science to reach that objective. And according to science, you are not doing enough. So basically, you have discretion, all the discretion under your policy power, your legislative power to decide how to comply with the Paris Agreement, but your decisions need to align with the Paris Agreement. So I think my first answer would be that courts are definitely on the limit. They're basically challenging or moving to the limit or the realm of public policy and legislation. But they have a new argument, or at least in some of the cases we see this new argument, is that it's not at the discretion of states to choose the best available science. The best available science exists, and science can be basically the benchmark to determine if the countries are doing enough or not doing enough. And I think this is how the discretion of states is more limited. And I think we see this especially with the recent advisory opinions on climate change, because now uh, the Inter-American Court of Human Rights, the International Court of Justice, the International Tribunal for the Law of the Sea, they all mention that this must be climate action must be guided by a stringent standard of due diligence. And this standard is informed by the best available science. So yeah, states have discretion to fulfill the objectives of the Paris Agreement or to define the particular measures to fulfill the objectives of the Paris Agreement, but they are subject to this strict due diligence and to the best available science.
Thank you for that, Jorge. I actually wanted to ask you if you think that especially the recent ICJ advisory opinion, is changing the legal baseline against which courts can also assess the ambition or progression of domestic NDCs, but you've essentially responded to that. I do want to hand over to the audience if there are any questions, any comments. Please feel free to unmute yourself and pose a question.
I see a question here from Rodrigo Juarez. The Greenpeace case, sorry, you mentioned made me wonder, how can we as a civil society can use cases like this to push government towards strong climate commitments? This is a very good question too, and I think now that we have a lot of cases in very different countries, now that we have the advisory opinions on climate change, I think it's basically we have the arguments. We already have the arguments to mention that the government needs to do more and it needs to be more ambitious. The climate action needs to be more ambitious. And now the ICJ mentions that if countries don't satisfy the standard of due diligence, this is actually the breach of an international obligation. So it's not responsibility at the national level or the domestic level. We also have a discussion on responsibility at the international level. So, and I think we will see this in, well, I'm guessing here, but I think in the next years we will see some contentious cases that actually deal with climate change, because this was an advisory proceeding, but I'm sure we will see more contentious cases at the international level. Um, and in Mexico, what I would say is we basically can use the same arguments. We have the right to healthy environment in Article 4. We have the principle of progressivity under human rights law. The Paris Agreement has been integrated into domestic law and legislation. So basically, we can use the same arguments. And in the Greenpeace case in particular, in the merits of the case, the main problem was that the plaintiffs did not provide sufficient evidence. But I think in other cases, we of course can provide more evidence, especially because science is advancing so much. So I think we will see more positive outcomes in these cases.
Lovely. Any other questions from the audience? Okay, in the absence of any questions, I want to ask just again for a slight little bit of interest. If you've thought about, obviously outside of the scope of the court cases that Mexico have been presented with, but if you've thought how the increasing movements to have ecocide criminalized or even the rights of nature movement, how that might have an impact on even states' NDCs, but also future climate litigation, especially brought by states, but also potentially, against multinational corporations. So if you've maybe engaged with that also in the research.
Yeah, definitely. And this is I think it's a very, very good question, especially in this recent context, because the Inter-American Court of Human Rights, and in its advisory opinion, I think it was one of the most progressive advisory opinions, and we were expecting that because the Inter-American Court can be very creative. In some cases, the Inter-American Court basically mentioned that, or noticed that a lot of countries are recognizing rights of nature in their constitution, their laws, their statutes, domestic judicial decisions. Um, and basically, the court mentioned that this is compatible with the American Convention on Human Rights. And not only is compatible, but is the most progressive interpretation of the American Convention on Human Rights. So basically, and I'm not saying that the Inter-American Court expressly said that all countries need to move to rights of nature towards the rights of nature or the recognition of these rights, but basically emphasized that the most progressive interpretation compatible with the American Convention is this new recognition or this new approach. And something that I can see from climate litigations in some countries in Latin America and in Mexico in particular is that most of the mechanisms to access to justice are designed to basically analyze if the plaintiff has been affected in some way. If, for instance, in most environmental cases, most courts in Mexico usually ask, okay, we understand that you're trying to protect the environment, but does this impact your health? Does this impact your property? Does this impact your I don't know, your housing. Um, and with the approach of rights of nature, we're moving from that discussion. We are not asking the people if other human rights, let's talk about the right to health, the right to property, the right to private life, have been affected, because the right to a healthy environment is a different human right. It's an autonomous human right, and it's designed to protect nature for its intrinsic value. This is something that the Inter-American Court mentioned in the advisory opinion, and something that actually courts in Mexico have been interpreting too. And now I turn to the last part of the question. If this decision from the advisory opinions will impact next of or future climate litigation cases, I think they will. Of course, advisory opinions are not binding because this basically the advisory jurisdiction is not designed to be binding. It's not a contentious case, but we can see that in most cases, these courts have legal authority. They're very prestigious, and in most environmental cases in Mexico, including the Mexican Supreme Court, the court basically adopted the same arguments of the Inter-American Court because they are more progressive, even if the decision is not binding. So I think what we will see in the next or the future cases is that basically courts in Mexico will adopt the same arguments or more progressive arguments. And this is a regional court. I think the impact of the ICJ will be even more because of course it's a lot of countries have recognized the authority of the court. We perhaps will see contentious cases. So yeah, definitely. I think these new approaches, such as rights of nature, will definitely impact new climate litigation cases, and the advisory opinions will help too.
Okay, we do have two more questions. I think we'll pose those two and then we can conclude the session. We have a question from Marisol Bortes, and she asks, when we are talking about global South countries and given the capacity constraints, especially in comparison to the global North, how do we qualify the requirement for best of science available? And to what extent do you think the adequacy of the indices are impacted by the capacities of countries?
Thank you so much. This is a very, very interesting question. And basically, what the Inter-American Court of Human Rights and the ICJ mention in their advisory opinions is that due diligence, and of course, this is due diligence standard applies to NDCs. This due diligence must be informed by the best available science, the national circumstances of that country or that state, and other relevant considerations. That are relevant in the particular case. The best available science, this is something interesting also from these two advisory opinions. All the courts mentioned that the IPCC reports reflect the best available science on climate change. But something that I actually was thinking is that they're not saying that the IPCC reports are the only source of scientific knowledge. And I don't think the IPCC reports should be the only source of scientific knowledge. But the ICJ does not explain how can we identify the best available science beyond the reports from the IPCC. The Inter-American Court of Human Rights does. They actually included a paragraph indicating some elements to determine if the knowledge in a specific case represents the best available science. And something that it's even more interesting from my perspective is that the Inter-American Court mentioned that this scientific knowledge needs to dialogue with the local, traditional, and indigenous knowledge. And I think this is essential because under the Paris Agreement, states must act according to the best available science, but also where appropriate in local, traditional, and indigenous knowledge. And this is something that I think it's often overlooked. We need to consider all these sources of knowledge and see how they integrate. And this is my interpretation of the Inter-American Court, of what the Inter-American Court said. I think the best available science needs to consider or also includes the local, indigenous, and traditional knowledge. So I think this is how we can identify the best available science and how do we qualify the requirement. So something that it's clear from the IPCC reports is that countries have different responsibilities, different historical responsibilities, different capacities. That's why the advisory opinions discuss the principle of common but differentiated responsibilities. So I think the adequacy of the NDCs are definitely impacted by the level of development, the historical contributions to greenhouse gas emissions and other factors, and also the standard of due diligence that applies to NDCs. So perhaps the answer was too very complicated. What I'm trying to say is that when we try to analyze the adequacy of an NDC, let's say the NDC of Mexico, we will consider the best available science. what the best available science says about the capacity of Mexico to contribute to climate action at the national and international level, the local, traditional, and indigenous knowledge, and of course, I think questions of historical responsibility. And this is something that the ICJ mentions expressly. We need to consider the historical responsibility of some states.
Thank you, Jorge. That also, I think, brings up the question or issue of how capacity constraints can also shape NDC adequacy, and also just emphasizes international cooperation when it comes to assisting, especially global South countries. I'm going to read out one question that was, I think, accidentally sent through direct message, but then you can respond to the last two. From Ricardo Esquivel, who asks, what is your opinion about judicial reform in Mexico and how this relates with climate litigation, especially in the Mexican Supreme Court?
Thank you so much for this question. This is particular to Mexico. Apologies if you don't find this especially interesting, but recently we had a judicial reform, and one of the main changes with this reform is that now judges and judges of the Supreme Court, justices, all kind of judges in Mexico will be elected through popular vote. Before this process, or before this reform, the process basically was designed to test with exams, examination, tests, the best candidates to occupy this kind of roles, judges. And in the case of the justices of the Supreme Court, they were appointed by the president, and the Senate needed to approve the designation. So basically, this change, and now we select justices and judges by popular vote. Um, I think this is definitely a challenge for environmental and climate litigation in Mexico, mostly because we have a lot of jurisprudence on environmental protection. We have a lot of precedents on climate change obligations, on the right to a healthy environment. And the new courts, I think, needs to not automatically discard or basically reject those precedents. I think they're very solid. We made a lot of progress during the years, and I think the new members of the judiciary should basically take that as a baseline and basically perhaps develop more progressive decisions, more progressive interpretations, but using what we already have. And this is not an obligation because, of course, judges can change their mind. This is something that can happen anywhere in the world. They can change their mind. Um, but now we have basically most of the judges in Mexico changing from one day to another. So I think it's likely that they want to change some things and some interpretations. But I think in the environmental cases and climate litigation cases, we have very important decisions, very important precedents, very important interpretations. So I think the greatest challenge is just to not lose these advancements and this progress that we have already made. So basically encourage judges to respect those precedents and to develop more progressive decisions, but using those precedents.
Well, thank you. And if we could just lastly also respond to Emilia and Liesel's questions. Should I read those out for you?
I see them in the chat. How countries like Namibia ensure, can countries like Namibia ensure that its recent oil discoveries and potential future oil production are aligned with its NDC, particularly in terms of balancing economic development with climate change mitigation? And the next question, do you have any thoughts on the role of children in climate litigation? I think I will start with the last question because it's easier. I think children definitely have an important role in climate litigation. Most of the cases in Mexico, climate litigation cases are presented or filed by children. And this is very important because the law in Mexico is designed to support plaintiffs that are children. The requirements are less strict. There are another rights that protect children. And basically, I think this is very useful in climate litigation. And basically, thanks to these movements from kids, from children, now we have decisions from the Supreme Court in Mexico recognizing the right to future, which is something very interesting in comparative law. So I definitely think they have an important role, and you can see that on the reports on climate litigation from UNEP and from LSE. You will see that children have a very important role in most climate litigation cases. So definitely, and I think that would be the case, and then in the future, definitely it's important. And the other question, it's more difficult because and I think this is something that we see in several countries in Latin America. The best available science, I think it's clear in the sense that we need to abandon um, basically oil production. We need to abandon fossil fuels if we want to align with the objectives of the Paris Agreement. But of course, some of the things that we have seen in the advisory opinions and that we see at the international negotiations is that the countries have common but differentiated responsibilities. They have different levels of development. And I think and a very important aspect in this discussion is cooperation, the obligation to cooperate. And this is something that the ICJ mentions because it's a legal obligation. Cooperation is a legal obligation. And under the Paris Agreement, one of the forms of cooperation is financial assistance and capacity building and technological transfer. And this is, I think, in the international conferences of the parties, this was seen as something voluntary, something completely political. But now, at least the ICJ and the Inter-American Court are mentioning that this is mandatory. This is a legal obligation under the Paris Agreement. And this means that the most developed countries need to provide financial assistance to less developed countries. And if they provide this financial assistance, capacity building, and technology transfer, perhaps there will be more opportunities to pursue sustainable development, to advance energy transition projects, and not depend on oil production and oil discoveries. Because in that case, we will basically won't change the course of action. We will stick to the same course of action, and according to science, we will not reach the objectives of the Paris Agreement this way. Of course, it's not easy. It's something that depends on the level of development and national circumstances. But I think cooperation is it's key to basically securing a more um, or our future that it's basically abandoning fossil fuels.
Wonderful, thank you. That brings us right to the end. Again, thank you very much for that informative presentation, Jorge. And thank you to our audience for your thought-provoking questions, as well as for attending. You'll find the recording through our usual channels. And yeah, thank you and have a good evening or a good day based on where you are based. Thank you.
Thank you so much again for the invitation, and thank you so much for your attention in this presentation. You can contact me if you have any further questions. Thank you so much.
Thank you. Goodbye, everyone.